Talking about persons, this definition covers all national measures liable to hinder the exercise of the fundamental freedoms or to make them less attractive. If a national measure makes a distinction between imported and domestic products when talking about products, or between nationals and foreigners when talking about persons, it is considered to be discriminatory. Concerning persons, we talk about a direct discrimination if this distinction is made according to the criterion of citizenship, so to speak an open discrimination in order to favor national citizens. When using a superficial neutral criterion, like the one of residence, in order to disguise this discrimination, we call this an indirect or a disguised discrimination. The message is clear. Both are prohibited. But not only discriminations, treating national and cross-border cases in a different way, are prohibited. Also a national law making no difference between imported and domestic products or between national citizens and foreigners can be qualified as a restriction to the fundamental freedoms. Therefore, the Austrian law only allowing packaged chewing gum to be sold from vending machines would be considered to be a restriction. The criterion is whether the chewing gum has been packaged. The criterion is not the origin of the product, Germany or Austria. Now, before telling you about the following differentiation, let's have a look at this man. In Austria, he has not only once run for president, he is also fighting for the right to open his shops on Sundays. From what you have heard so far, such a national law prohibiting a businessman to do so would be qualified as a restriction. The result would be that such a national law could be challenged by the fundamental freedoms, even though the reason behind this law may be rather a religious one than the concept of restricting trade across the EU. Knowing this background, let me show you how the ECJ has tried to find an appropriate solution for the situation, meaning not having to force the member states to allow shops to open on Sundays. In the Quai judgment, the ECJ is referring to the increasing tendency of traders to challenge any national rules in the light of the fundamental freedoms. Therefore, the ECJ had to find an exit strategy, or in his words, to re-examine and clarify its case law. The ECJ then summarized his case law in paragraph 15 of his judgment, establishing the category called product-related measures. So those relating to the designation, form, size, weight, composition, presentation, labeling, and packaging of the product. The second category comprises so-called selling arrangements, which basically don't fall under the scope of the fundamental freedoms. As such general exceptions can always be dangerous, as they might be misused, the ECJ had to come up with two requirements which selling arrangements must fulfill before they fall outside the scope of the fundamental freedoms. First of all, they must apply to all relevant traders operating within the national territory and affect in the same manner, in law and in fact, the marketing of domestic products and those from other member states. So therefore, a national law which would not allow to open shops on Sundays has similar effects on imported and domestic products and therefore would fall outside the fundamental freedoms. In such a case, the checklist would come to an end. Now, if this selling arrangement, prohibition to open shops on Sundays, for example, would only apply to those shops which sell foreign goods, there would be a different effect on imported and domestic products, and therefore the checklist continues. No matter whether we have had a product-related measure or a selling arrangement with different effects on imported and domestic products, there is a second exit strategy. Similar to the just mentioned Keck case law, it cannot be found in the treatise, but has been invented by the European Court of Justice. I promised not to do rocket science, so I will try to explain you the substantial effects theory as simple as possible. This is the definition of this theory, and as you can see, the definition is not really useful to be applied to a specific case in order to know whether you exit the checklist, because the effects of this measure on the fundamental freedoms are too uncertain and indirect, or if this is not the case. Imagine a scale of intensity, where the most extreme measure, for example in the context of the free movement of workers, would be the expulsion of a migrant worker from the territory of another member state. A mere discrimination would still be prohibited, but not regarded as extreme. The same would hold true for a mere restriction regarded as less extreme but still prohibited. If a certain threshold of an obstacle has not been reached, those kind of cases can be sorted out by means of the substantial effect theory. This concept is similar to the one of the de minimis dating back to Roman law, meaning that the praetor, a kind of Roman judge, didn't concern himself with trifles, issues of minor importance. This concept can also be found in European Union state aid law. If you don't exit the checklist at this stage, the show goes on and we will finally come to the level of justification. Let me very briefly explain this concept of justification by means of an example in the context of national criminal law. If you harm or even kill another person, this is basically not allowed under national law. The same holds true for the member states. Until this stage of the checklist, they would breach EU law by putting an obstacle to the fundamental freedoms. However, coming back to our example, if you harm or even kill another person because he or she has attacked you or your family, you might be justified because of legitimate self-defense. Now, same applies in our context. There might be some values which are more important than the free movement of goods and persons. Now, what are those reasons of justification and where can they be found? As you can see, in case of a discrimination, they can be found in the treaties, whereas in case of a restriction, a member state can also rely on a second category of reasons, which have been developed by the ECJ in its case law. For the free movement of goods, for example, those reasons can be found in Article 36 TFEU. As mentioned, in case of a restriction, a member state can also rely on those reasons which have been developed by the ECJ in its case law. Last but not least, there is a very important hurdle that has to be overcome. The reason why this last hurdle is such an important one is due to the fact that a lot of ECJ cases are finally decided at this last level in terms of whether a national measure is in accordance with the fundamental freedoms or not. To hit the nail on the head, this last examination is about the question whether the national measure overshoots the mark. This so-called review of proportionality is about the question whether the measure is appropriate, necessary and reasonable. In other words, you have to ensure that the national measure does not go beyond what is necessary in order to achieve the legitimate objective. In this course manual, you can find some categories of cases which will illustrate this concept. It can be summarized that this checklist can be applied to all fundamental freedoms. Only those parts of the checklist which only refer to persons are not relevant for the free movement of products, as this right is attached to the product itself and not to the owner of the product. Having said that there is one single checklist for all fundamental freedoms, some terms don't make sense when talking about persons, so here you can find the equivalent terms. Although there are some details to know, you could see that this is not rocket science, and having understood this checklist allows you to solve an almost unlimited number of potential cases which can be challenged in the light of EU law. So if you cannot already get a satisfying solution according to national law, you can try to get rid of a national prohibition by arguing that it is against EU law. Only if you face a prohibition on both levels, well, then you will have to accept it. That's it. All the best for surfing through solving your case in the context of the fundamental freedoms.